Morning, everybody. It is Monday, May the 4th. May the 4th be with us all. And this video is going to be the second part of the Supreme Court lectures. Just as usual, letting folks file on in. Trying to get my chat up and go. There we go. Okay. I'm like, am I not actually streaming? Nobody's around yet. I'll wait a little longer. Hope everybody is doing all right out there. Both of you watch. Oops. Just realize it probably helps if I get my microphone up to, pointed at my mouth. Anyway, waiting for folks to come in. Doesn't look like I really have anybody watching today, which is always fun. Yeah, if you are watching this on tape delay and you can make the live lectures, I mean, it's not required. Don't let me make you think it's required, but I do enjoy having the audience, even if it's just seeing, for watching now on my screen. It's nice to know that there's somebody other than myself who's actually watching this. Oh, hey, there's somebody. Hello, somebody. But anyway, so given that, we can go ahead and get started talking about the Supreme Court and how it operates. The Supreme Court is our nation's highest judicial body. They are the people who decide what it is that the Constitution means. And it's kind of a clunky and archaic institution because there are only 9 of them, and they don't take all the cases that come in front of them. So Supreme Court is basically on basically like an academic calendar, maybe kind of a late starting academic calendar. Typically, they open the first Monday on October and are in session for about 9 months. Actually, Supreme Court watching time is now. We're probably going to, I don't actually know what impact the whole corona thing is going to have on the Supreme Court. But in normal times, we would be watching the news on Tuesdays in the coming weeks, because Tuesdays from late May to late June, that's typically when Supreme Court decisions come out. So keep your eyes out for that. That's going to be coming. The Supreme Court is not a trial court. Supreme Court is not a trial court. They are an appellate court, and so that means that unlike your district courts and things like that that spend their time. Good morning, Isabella. That spend their time trying to figure out guilt from innocence, fact from fiction. The Supreme Court primarily rules on questions of law. In cases where different facts are at issue, the Supreme Court often remands cases or sends them back down to a lower court to have that case be tried again, rather than ruling on questions of fact themselves. Morning, Kimberly. So, court's in session for 9 months out of the year. Much of that time, especially early on, is taken up with oral arguments. But I'm getting ahead of myself. We'll get there. So case selection. I'll get to amicus briefs in a little bit here when we talk about oral arguments, so just put a pin in that. Case selection. So there are some formal requirements for a case to be heard in front of the Supreme Court. The Supreme Court does not have to hear all cases that are appealed to it, and in fact it doesn't hear all cases that are appealed to it. Of the thousands of cases that are appealed to the Supreme Court every year, I think it's only about like 150 that actually get heard. Okay, so the court agreed to hear 73 cases. Okay, 73 cases out of, as I said, literally thousands, tens of thousands that appeal their case to the Supreme Court. So just getting to the Supreme Court is enormously difficult, and the justices do get to choose which case it is. Which cases come before them, right? So the Supreme Court has a rule. The way they select cases is called the Rule of 4, which means that of the 9 Supreme Court justices, at least 4 judges must agree to hear a case before it can come before the court. That's not a majority of the 9-person court, but it is a strong minority. And if the justices agree to hear a case, they issue what is called a writ of certiorari, or it's sometimes abbreviated just cert. So sometimes you'll see in legal writings, you'll see, granted cert, denied cert. That means, called up by the Supreme Court or not called up by the Supreme Court, which is, as I said, the much more common option. So there are particular conditions that must be met for a case to be heard in, not just in the Supreme Court, but in any federal court. And you might think that these conditions are relatively easily satisfied, but it's actually surprising how often Supreme Court decisions get tossed out on issues of standing in particular. So, for a case to come before the Supreme Court, there are 3 conditions that it must satisfy, or actually to come, like I said before, any of our federal courts. First, there must be a legitimate controversy. The courts do not take on hypotheticals in the United States. In the United States, the courts are there simply to deal with cases that have already arisen. So you cannot, for example, look at a law and say, hey, I think that law is probably unconstitutional and was going to be used to oppress somebody. You can't sue until you actually, until somebody's actually being oppressed under the law. So that was actually an issue during the Trump administration's Muslim ban efforts. By the way, a version of that is still in effect. A lot of people forget that. And also, in the middle of all this coronavirus stuff, there are still kids in cages on the southern border. So, fun stuff there. But a major issue with the Muslim ban cases was that it was so very hard to find a plaintiff, because in order for somebody to be a plaintiff in that case, first off, there had to be a legitimate controversy. So that means somebody had to be denied entry into the United States under these rules, right, in the case of the Muslim ban. Second, the plaintiff in a court case must have what is called standing, which means that you cannot file a court case on behalf of somebody else. In order for you to have standing, you must be the actual party injured in the case. And so now you may be seeing the problem with the Muslim ban is that the only people who were able to bring a Supreme Court case against the Trump administration were people who had flown to the United States and been denied entry, and most of those people were back in like Yemen and Saudi. Actually, he never banned Saudi Arabia because they're our allies. We want their oil. But Yemen and Jordan and wherever else he banned people from. Very hard to find court plaintiffs who have standing in those cases. So it's actually reasonably common for court cases to get tossed out on standing. I'll mention the case, the 2012 case of U.S. v. Windsor, that many of us thought would finally be the case that expanded marriage equality nationwide. I really wish it had been, because it had a much easier name than the one that actually did it. The case that I'm talking about is the case of what was originally called Perry v. Schwarzenegger. Because Schwarzenegger, in his capacity as governor of California at the time. And the Perry in that case was a couple of partners who in California were being denied the ability to get married because they were lesbians and not an opposite-sex couple under California's Proposition 8, which was a same-sex marriage ban, for those who don't remember. It was a traumatizing time for me, I assure you. I was really proud of my mom, though. She hung up this big banner to stop the hate, no on 8. But anyway, so by the time this case gets to the Supreme Court, it's Hollingsworth versus Perry, and the case ends up overturning Proposition 8, but it did it by such a narrow technical route that the decision ended up only applying to California. The Supreme Court actually didn't decide anything in the case. They dismissed the case because they said the plaintiffs in this case were the or who were the original defendants of the lawsuit. The plaintiffs were not the state government, they were the people who organized the initiative in the first place, because the state of California is like, yeah, we're not defending your homophobic initiative, no thank you. And so the Supreme Court basically says that because, the state government is the one being sued, and these folks didn't represent the state government, and the state government had just folded and said, you know what, we're not defending this law at all because we don't believe it's right. So that case got tossed out on standing, said that the Prop 8 people did not have standing to sue. That case could have overturned same-sex marriage bans nationwide, but because of that very narrow technical ruling, it only applied to California, and the rest of the country would have to wait 3 more years, because that case was heard in 2012. Finally, a case cannot be moot in the federal courts. And mootness is a concept about whether or not there's something that judges can actually do to fix something for the people involved. If something is moot, that means that there's nothing that the Supreme Court can do to fix the problem. And the best example I have of this is the case of Roe versus Wade. So, several previous challenges to abortion laws around the country had been thrown out for mootness because in each case, a pregnant person filed a lawsuit seeking to have an abortion law overturned so that they could get an abortion. By the time the case made it all the way up to the Supreme Court, well, the baby had already been had, and you can't abort a baby who's already been born. So in most of these cases, the Supreme Court could not go back and retroactively grant that person an abortion. And so they actually had to give a special exception in the case of Roe versus Wade, because as I said, the same exact thing happened to Norma Jean McCorvey, who Jane Roe in Roe versus Wade. She cases under a pseudonym. Same thing happened to her. She filed to try and overturn Texas's abortion law so that she could get an abortion, and it took so long to work the case through the Supreme Court that she had her baby, and so the case was deemed moot. So the Supreme Court actually, in the case of abortion, because this had happened a few times, actually gave a special exemption to Roe and Roe versus Wade. To avoid the mootness clause, because normally they would have been unable to hear that case. So those are the formal requirements, right? Got to be a legitimate controversy. There has to be standing. Can't be a moot case. 4 Supreme Justices have to agree to hear it and issue a writ of cert. There are a lot of informal reasons why the Supreme Court chooses its cases as well. One of the biggest ones is when two lower court cases decide the legal question differently. So I mentioned before that in judicial circuits, the rulings of circuit courts are binding only within their judicial circuits, right? So I mentioned how some circuits are kind of hippy-dippy liberal, like the Ninth Circuit out here west. Some of them are extremely conservative, like the one with Texas, Louisiana, and Mississippi in it. Surprise, surprise, right? And as a consequence, it's not all that uncommon for two appellate courts to rule different ways on the same controversial issue. I gave the example of transgender rights before because that happens to be something that is actually LGBT rights in general. There are two cases that are up before the Supreme Court right now, and those of us in the community are rather worried because these cases have of people asserting that they have a religious right to discriminate against LGBT people, and if the Supreme Court decides along with that, it could invalidate state laws that currently protect us, like the state laws that we have here in Nevada. So people like me are very worried about this decision. But anyway, the way that the ruling exists right now is that in the Seventh Circuit here, that includes Wisconsin, Indiana, and Illinois, the Seventh Circuit has ruled that discriminating against transgender people constitutes unlawful sex discrimination under the Civil Rights Act. So that, if you fire a trans woman for wearing because she's wearing a dress instead of a suit, well, then you're firing her for, doing something that you would not fire somebody who was assigned female at birth for doing. And so therefore, it is inherently sex discrimination, goes the argument. Same thing with discrimination along sexual orientation. If you fire me for being a lesbian, then you are firing me for dating women, which is presumably something that you would not fire a male professor for, and so that constitutes, according to the Seventh Circuit, sex discrimination under the Civil Rights Act. The Fifth Circuit, the conservative Texas one, says actually, in 1964, first off, they weren't really trying to protect sex discrimination in the first place. If you'll remember back to that lecture, the word sex was inserted into the act as a poison pill, a mischievous joke, according to the Equal Opportunity Employment Commission. But conservatives said that, furthermore, even if the Congress had been trying to actually protect against sex discrimination in the workplace, the way that was understood in 1964 was really only to mean, between cis men and cis women, that LGBT people in most states were still criminalized when the Civil Rights Act was passed. And so, right now, the Fifth Circuit went with that and said, okay, no, the Civil Rights Act really only applies to discrimination between, cis men versus cis women. Transgender people aren't protected based on their transgender status. Gay people aren't protected based on their sexual orientation, etc., etc. The Seventh Circuit found the exact opposite. And so, it is no surprise that we are waiting on decisions in two cases. One about sexual orientation called Zarda v. Altitude Express, which is, of all things, about a skydiving instructor who was fired for being gay. There's Stevens v. Harris Funeral Homes, which is about a trans woman who was a funeral director in Michigan, was fired for being trans. So we're going to see those decisions very shortly because, again, there is a disagreement between two lower courts. Right? Other reasons why the Supreme Court selects cases: if there's a lower court ruling that conflicts with an existing Supreme Court ruling. So, Lawrence v. Texas is my example for this one, and I'm sorry, yes, all my Supreme Court examples are gay. Just live with it. But If a lower court ruling conflicts with an existing Supreme Court ruling, the Supreme Court is more likely to take that up. So um, when the Fifth Circuit ruled in Lawrence versus Texas that laws barring the criminalization of homosexuality should be illegal, the Supreme Court was like, well, that conflicts with our existing precedent, because if you'll recall, there was a Romer v. Evans, a Georgia precedent from 1986 that said that homosexuality was not included in the constitutional right to privacy because it was criminal conduct. Ugh. Again, I was alive when that decision was handed down. And so in 2003 in Lawrence, the Supreme Court took that case up because they have a case from one of their more conservative circuits that conflicts with existing Supreme Court precedent. So they're going to take that up to resolve the question once and for all. And usually the result of that is that they overturn that lower court ruling. Not the case in Lawrence. In Lawrence, they upheld it, thankfully. But in most cases, they overturn that lower court ruling and conform the ruling to existing Supreme Court precedent. Remember that precedent matters in our legal system. Old cases determine how new cases are decided. If cases have significance beyond the two parties involved, so those cases that I mentioned, Altitude Express and Harris Funeral Homes, those both have significance to every LGBT person in the entire country and every bigot who wants to fire us for being gay, right? So there's significance significantly beyond just this one gay skydiving instructor who actually unfortunately is no longer with us. He died in a skydiving accident about 6 months after filing with the district court, but his estate's pursuing the case. So significance beyond the two parties involved. That is a way that the Supreme Court selects cases. Finally, a big major factor in Supreme Court decision making is if the U.S. government's a party, right? Cases involving the federal government often touch on issues between citizens and their governments, about constitutional rights, things like that. And so it's more frequent that the Supreme Court will hear a case when the federal government is either plaintiff or defendant in that case. And that's also why you'll remember if I mentioned on my last lecture that the Court of Appeals for the Federal Circuit is kind of like the Supreme Court farm team, right? Because the Federal Circuit deals with all the cases where the U.S. government's a party. The Supreme Court deals with a lot of cases where the U.S. government is a party. And so that ends up being a pipeline to Supreme Court justiceships. Okay. Any questions so far? That was all just on Supreme Court case selection, believe it or not. Okay, seeing nothing, I'm going to move on. So how does the Supreme Court actually operate? What does it do? How are these cases decided? Well, first thing that happens in the Supreme Court process is you get oral arguments. Let me see if I can't find you a picture of what that looks like. Actually, I can't find you a picture of it because cameras are still not allowed in the Supreme Court. You can get the audio of oral arguments, and you can see what the room looks like here. But due to archaic government regulations, you actually can't see what oral arguments in the Supreme Court look like, because cameras are still not allowed in the courtroom. But you can see what happens here is that you'll get, there's 9 chairs up here. Guess who sits there? Obviously the justices. and you'll have some folks from the plaintiff's side, some folks from the defendant's side. You've got some chairs for public audience, because these sessions are open to the public. You just can't photograph or video record them. And oral arguments are short. So very, very, very short sessions. So you can see here is the argument sheet for Monday, October 7th. This is cases that were heard for oral arguments. And you can see 1 hour per case. 1 hour, 1 hour, 1 hour. So the Supreme Court heard 3 cases that day. It was 1 hour each. And you'll notice that in most cases, that hour is split up evenly. Half an hour for the plaintiff, half an hour for the defendant. This is where I'm going to talk about amicus curiae. As you can see in this particular case, we had the United States Solicitor General serving as an amicus curiae supporting the respondent in the case of Collar v. Kansas, which I have no idea what it's about. I could look it up. But anyway, an amicus curiae brief is a friend of the court brief. Amicus, if you're a Spanish speaker or have vaguely encountered the Spanish language before, you might recognize the word amigo, friend, from the same Latin root, amicus, and then curiae means court, so friend of the court brief. A brief submitted by a person or a group who is not a direct party to the case, but has some sort of argument to weigh in. So sometimes these amicus briefs will come from activist groups. Sometimes they will come from, as you can see, the federal government. Sometimes like the Office of Legal Counsel will step in on behalf of some other federal agency. And often the court will actually invite amicus briefs from interested parties. So oral arguments are heard, 30 minutes per side, and if you're thinking of a courtroom where the attorneys get to go up in front of the judges and make these long, drawn-out speeches, and well, that's not happening in the Supreme Court. I'm not going to play any of the audio, but if you want to listen to the audio, supremecourt.gov, click on Oral Arguments, Argument Audio. It's right here. You can hear all of the oral arguments in the Supreme Court session. So if I wanted to find, where are the arguments on Zarda v. Altitude Express? There it is, RG and GR Harris Funeral Homes. Right? So if I wanted to hear that argument on the trans woman who got fired for being trans in Michigan, that's right here. But no video. But if you listen to that argument, and I'm not going to play it because it is terrifyingly boring, what you'd see is that most of the oral argument period is taken up by justices asking questions. If you are preparing an argument before the Supreme Court, you do your testimony in written form, because that 30 minutes you have in front of the highest court in the land, you want to maximize that time. So most of that time is taken up with direct questioning from the justices to the attorneys representing the various parties in the case. Most of the long lawyer talky bits are actually done in writing for the Supreme Court. Court is in session. They hear oral arguments on Monday, Tuesday, Wednesday. They only hear them for an hour at a time. There's only usually 3 cases going on, so a very academic schedule. 3 oral arguments, an hour each. That's kind of a standard load. Maybe a little light. And then on Thursday and Friday, the justices make their decisions in conference sessions, which are open only to the Supreme Court justices themselves. And that's when they actually sit down and vote on how they're going to rule in a given case. Every Supreme Court justice gets one vote. They're all equal. We do have a Chief Justice, but the Chief Justice doesn't get any extra power on the vote. And in those conference sessions, the justices will vote, and then they will write an opinion expressing the opinion of the court, as it were. There are actually several different types of opinion that can be produced by the court. Every case will have a majority opinion. That is the official statement of the court. That is what becomes court precedent. That is what goes down in history. Oh, good morning, Kathy. That's what goes down in history as law, right? You may sometimes see, although not always, but you may sometimes see a concurring opinion, which is a statement that agrees with the majority opinion, but for different legal reasons. So, for example, on the case that eventually did end the ban on same-sex marriage in the United States, that was a Bergfeld v. Hodges, they eventually struck down same-sex marriage bans on an equal protection claim under the 14th Amendment. But you could imagine a justice saying, actually, I think the reason these things are unconstitutional is because they violate the full faith and credit clause of Article 6. And so I'm getting to the same place, right? I'm still saying, hey, this ban is unconstitutional, but I'm getting there by different legal reasoning, and that's why I might file a concurring opinion. Finally, you may see any number of, well, at least not any number, somewhere between 1 and 4 dissenting opinions, because if there were 5 of them, they'd be a majority. But a dissent is a statement on behalf of the justices who voted in the minority as to why it is that they voted against the official legal ruling of the court, what their reasoning was, what their arguments were. And sometimes those dissents can become precedent later on down the road if the Supreme Court decides that they ruled in error at some point. So then those decisions, as I said, those written decisions are published usually on Tuesdays in late May through June, so late spring, early summer. Lots of Supreme Court decisions have the same anniversary date because they're all handed down within about a month of each other. Also gives me the whole, I graduated high school into a world where being gay was still illegal by like 3 days, because that decision came out in late June. So be watching for Supreme Court decisions coming out over the next couple months. And spoiler alert, they're all probably going to be awful because this is the Kavanaugh, Gorsuch, Trump court, and it's probably going to suck a lot the next month or two. Emotionally prepare yourself, particularly if you are anywhere on the LGBT spectrum, because we may get some very, very bad news in the next couple months, right in the middle of a global pandemic. It is lovely and wonderful. Let's see. As I mentioned in my last lecture, the Supreme Court is a relatively low-resource institution. Congress has thousands of staffers, so does the president. The president has millions of bureaucrats, theoretically at his beck and call. It's more complicated than that, as we said in Chapter 15. But the Supreme Court justices don't do everything on their own. They do have some help. Supreme Court justices get a number of law clerks. But it's not that big a number. The number is between 3 and 4. Right? So Supreme Court justices get 3 to 4 law clerks for them. And those law clerks are typically very recent law school graduates. folks who help the justices write opinions, reach decisions, and most importantly, sort through the piles and piles and piles and piles and piles of petitions of people asking to have their cases heard before the Supreme Court. So yeah, law clerks are a thing. When I say they're typically recent law school graduates, I do mean of the very best law schools, right? If you just walked out top of your class at Stanford Law, then maybe you have a chance at clerking for the Supreme Court. If you graduated top of your class at Harvard or Yale Law, yeah, maybe you have a chance at clerking for the Supreme Court. And if you do clerk for the Supreme Court, your life is made. Your career is heading for the stars. Law firms will sometimes pay up to $250,000 signing bonus for somebody who has been a Supreme Court clerk. These are very important positions. Similar clerk positions exist throughout the federal judiciary, both at the district court and circuit court levels, but the Supreme Court ones are extremely, extremely prestigious, and so therefore highly, highly competitive. But so we got 9 justices. They get, let's just say they don't all get 4, but let's just say they all get 4. 9 times 4 is 36. 36 people who make up the top of our federal judiciary. This is what I mean when I say that our judiciary is very, very low resource, right? Doesn't actually have all that many people in it, and really does kind of rely on the other branches for enforcement. Let's see. What do I want to say about confirmation battles? So one of the only ways that we have much influence at all over who gets to be on our Supreme Courts are, of course, through the confirmation hearing process in the United States Senate. Supreme Court justices are, like any justice in the federal system, are appointed by the president and confirmed by what is now a bare majority, thank you Mitch McConnell, of the U.S. Senate. And that didn't used to be a big deal. Confirmation hearings used to be, mainly about whether the person was qualified to do their job. Presidents typically nominated reasonably ideologically moderate, leaning in one direction or another, but they typically didn't nominate real serious radicals to the court. And according to the confirmation hearings, were pretty, bipartisan sorts of affairs. It's understood that, hey, while we're in office, we get to nominate judges. While you're in office, you get to nominate judges. That is not the world we live in anymore, by any stretch of the imagination. Since Ronald Reagan tried to nominate a conservative activist by the name of Robert Bork to the court, and Democrats organized a significant resistance to that nomination because they didn't want a conservative ideologue on the court. Supreme Court confirmation battles have been partisan debates that engage pretty much everybody in American politics, because pretty much everybody is affected by business before the Supreme Court at one point or another. Since Robert Bork had his nomination borked, we have since seen confirmation hearings become raucous partisan debates. And we've since seen the Republicans using every procedural advantage that they possibly have in order to drive the confirmation process and drive the federal judiciary into the arms of the right wing of this country. This is what we've seen with Mitch McConnell stealing the Supreme Court seat from Obama. So the Senate Judiciary Committee normally holds hearings and recommends on whether a nominee should be nominated to the full Senate. Traditionally, that committee has honestly considered any nominee a president has put forward and has typically recommended confirmation for any nominee who's at least reasonably qualified and not an absolute loon. But in the case of President Obama, the Senate Judiciary Committee said that they would not hold hearings. They just weren't going to do it. We're just, not going to hold hearings, and we're going to recommend to the whole Senate that we just kind of sit on this thing for a year and a half until hopefully we win the election and then Trump gets to appoint Neil Gorsuch, which is exactly what happened. So Supreme Court confirmation battles are an enormous part of our partisan struggle today. Indeed, they're a lot of people's reason for voting for president, right? How many times, I can't tell you how many times I've heard somebody say something along the lines of, well, I hate to vote for Joe Biden, and good God, I hate to vote for Joe Biden, but, Ruth Bader Ginsburg is going to die. And when she does, I really want a Democrat to be in the White House so that we don't get yet another conservative, rabidly conservative 40-year-old Supreme Court justice, which is what we've got a whole lot of. We've got a lot of very young conservatives and a lot of very old liberals. Actually, not very many old liberals. Any questions on the Supreme Court and how it operates? Alright, seeing nothing, let's move on. How do these people decide? How do they make their decisions? We've got 9 unelected individuals who basically get to decide what the law means in America. How do they make those decisions? Well, judges would like you to believe that judges decide case based on legal facts and precedent alone. That they look at the law, they look at the facts in the case, they call balls and strikes, right? That they're the referees of our society. That they decide cases based on previous rulings, just based on previous precedents, which is called the principle of stare decisis, by the way. It means stand by the things decided, and it means, when we decide a case one way, we decide similar cases that way going forward, right? So justices are going to want to say, hey, we look at the law, we look at the cases, we look at the precedent, and that's how we make up our mind. And that's not wrong, right? Sometimes justices even surprise us in their ideological leanings when they actually do make a principled decision based on the role of law and precedent. When, for example, Chief Justice John Roberts, normally a solid conservative vote, actually ended up being the swing vote in favor of the constitutionality of Obamacare. Why? Because, he read the law and he couldn't honestly decide that passing a new tax on people who don't buy health care was unconstitutional. Supreme as you're probably already guessing, most of the time, Supreme Court ideology is the most powerful predictor of Supreme Court votes. So yeah, Kennedy's gone. But yeah, so the strongest predictor of Supreme Court justices' beliefs is absolutely their ideology, their partisanship. And we have, at this time, a Supreme Court that is actually historically conservative, right? You can look at, this is the average ideology of the Supreme Court. That's Earl Warren. But you can see that the court has been trending conservative and more conservative and more conservative for decades. This doesn't even include Trump years. This is just 2010. So beyond just the liberal conservative dimensions that we're all familiar with, there's also a division between pragmatists and originalists on the Supreme Court. Pragmatists are those who interpret the Constitution as a living, changing document. Right? A pragmatist says, hey, the Constitution was great and all, but it was written 240 years ago. Can we... When we read the Constitution, we bring our modern understanding with it. We can't not. And therefore, to interpret the document's text absolutely literally is folly, right? It's ridiculous. It's a document that we have to bring our own experiences, our own understandings to, because we live in a world that is so very different than the one that our Constitution was written for. Typically, the pragmatist argument is more common among the liberals, among the left, whereas conservatives tend to be more originalist. Originalists say that, look, we expect people to follow the law, right? And if the law changes every time our modern sensibilities change, then how can we expect anybody to even know what the law is at any given moment? If we allow the document's text to change based on our own understanding, then that would make it very difficult to uphold any sense of the rule of law. So originalists say that you've got to look very literally at a document's text. You've got to look at the understanding of the words as they were understood by the people who wrote them. And so the originalists are people who go back to things like the Federalist Papers. And they're like, okay, well, what was James Madison thinking when he set up our Constitution this way? What would James Madison have understood these words to mean when he wrote them? Sort of thing, right? Normally, as I said, more originalists tend to be more conservative. Pragmatists tend to be more progressive. But that does change based on different issues. So, for example, gun control. There's almost no historical evidence to suggest that the Founding Fathers wanted to protect an individual right to carry an AR-15 into Target. There's no evidence to suggest that was what they were trying to do. But conservatives have increasingly taken a pragmatist, living document view of the Constitution and said that, well, because militias aren't really a thing anymore, then the Second Amendment should really cover all personal ownership and carrying of firearms, right? Whereas the progressives in this case are being more originalist and saying, no, that's not what the amendment says. Look, it says right here, a well-regulated militia, right? So it does vary, but typically you see more pragmatism among the progressives, more originalism among the conservatives. And by the way, meet your Supreme Court, folks. Let's see. They don't just have like a meet your justices button about the court. Justices. There is the current Supreme Court. In the front row, we have Justice Stephen Breyer. He is a liberal. There's Justice Clarence Thomas, a staunch conservative. That is Chief Justice John Roberts there. He's another staunch conservative. He's a W. Bush appointee. The notorious RBG, Ruth Bader Ginsburg. Over here is Samuel Alito, another W appointee. Back there is Neil Gorsuch. That's the Supreme Court seat that Mitch McConnell stole from Obama. There's Sonia Sotomayor. She's an Obama appointee. There's Elena Kagan, and she's also an Obama appointee. And there is Justice Brett Kavanaugh, who's obviously the most recent Trump appointee to the court. So, liberal, conservative, conservative, liberal, conservative, conservative, liberal, liberal. So you got 4 liberals, 5 solid conservatives on the Supreme Court right now. And, Ruth Bader Ginsburg is this tiny, frail bird woman, although, there are articles about like her workout routine because we all want to know if she's going to survive the Trump administration. Ruth Bader Ginsburg, take my organs. But apparently she can bench more than I can, so I'm not super worried about RBG surviving the year. She seems to be okay. Fingers crossed, though. Knock on wood. So as I said, we're living in an era of an increasingly conservative Supreme Court, and that doesn't even begin to approach what's happening to our judiciary in the Trump era, and we're going to have to be dealing with that for decades to come. Most of those guys, as you saw, are pretty young. I mean, not like young, but like, not really old. And most of the conservatives are young, most of the liberals are old. So, RBG and Stephen Breyer got to hang in there for us. So how else do justices make decisions? Ideology is a big one. The law plays a role. Collegiality and peer pressure. Justices influence one another. They spend a lot of time with each other. Remember, there's only like a couple dozen people who work in the Supreme Court building. There is a basketball court at the Supreme Court. Some people joke and call it the highest court in the land. But the Supreme Court justices hang out and play basketball and work out in the Supreme Court gymnasium and, spend a lot of time around each other. Collegiality makes a difference. Peer pressure makes a difference, especially when dealing with issues of institutional concerns and judicial reputation. Justices worry about the standing of the court. Right? Are my decisions going to be respected? Is this going to improve the standing of the institution of the Supreme Court or not? Marbury versus Madison was an example of that, right? Justice Marshall didn't want to come down with a decision that future presidents, or that Thomas Jefferson would ignore, and set a precedent of presidents, ignoring the Supreme Court in the future. Right, so came down with a decision that protected the power and integrity of the Supreme Court. Any questions about judicial decision making? So we're going to go into 19 cases you should know next. Hearing nothing. 19 cases you should know. We talked about Marbury versus Madison already, so I'm not going to go over it in too much excessive detail. But Marbury versus Madison was a case involving a dispute over the appointment of a judge at the very, very, very tail end of a president's term. And in this case, the Supreme Court gave itself the power of judicial review. Basically said, oh, by the way, we're allowed to overturn acts of Congress. That's something we can do. So we're going to do it. So 1803, Marbury versus Madison, very important case because it establishes the power of judicial review. 1819, McCulloch versus Maryland. McCulloch versus Maryland was about the first Bank of the United States, which was an institution established to print and coin money for the country. It was established in Baltimore, Maryland, and the state of Maryland tried to tax it, which I love. I mean, such a ballsy move. It's like, oh hey, the money printer is right here. Let's try and tax it 10%. So the state of Maryland tries to tax the U.S. Mint, and the Supreme Court basically says, no, you can't do that. That the power to tax includes the power to destroy, so that state governments are not allowed to tax the federal government. We had 1857's case of Dred Scott versus Sanford, which we have gone over in detail in this course before. If you'll remember, Dred Scott was a case about a slave who was taken to a free territory and then returned to slave legal Missouri, and who argued that he should be awarded his freedom for crossing that border. If you'll recall, that is also the worst Supreme Court case in American history because it opened the door to slavery in all federal territories and actually significantly accelerated the development of the Civil War. Also birthed the Republican Party in opposition. We have 1886, so 100 years before I was born. Santa Clara County versus Southern Pacific Railroad. The Supreme Court case dealt with some obscure tax provisions surrounding state land grants given to railroads in the mid-1800s, but the important thing to remember about it is that, and this is true, a Supreme Court clerk wrote in one of the margins of the opinion that corporations should be treated in the same way as natural persons for the purposes of this particular tax provision. And that precedent has led to, well, this, right? The world around us, where corporations have significant legal rights to do things like buy our elections, right? That's all under Santa Clara County v. Southern Pacific. We have 1896 Plessy v. Ferguson, the second worst Supreme Court case of all time. That was the one that said that segregation was A-OK, right? Separate but equal is all right with us. 1905's Lochner versus New York. Lochner was a case about bakery law in New York that said that employees in a bakery could not be made to work for longer than 10-hour shifts. And the Supreme Court struck it down as an unconstitutional imposition on Americans' freedom to contract. If you want to work 12-hour days in a bakery, that's between you and your employer. Of course, it's really up to your employer, not you, right? But so Lochner versus New York began the Lochner era, a period of about 20-25 years, where the Supreme Court was hostile to things like workplace safety regulations, overtime laws, minimum wage restrictions. It's a very difficult time for workers' rights. One case where the Supreme Court actually reversed itself during that era was 1908's case of Mueller v. Oregon, where a state law in Oregon set a maximum shift limitation, said that women in Oregon could not be made to work more than 8 hours because, of course, we are the fragile, fairer sex. And the Supreme Court actually said that that was constitutional and acceptable, that the state had an interest in protecting women from being overworked. But, men, go screw yourselves. So 1908's Mueller v. Oregon said that different laws for different genders could be appropriate. 1919, we have Schenck versus the United States. Schenck versus the United States is the case that establishes the clear and present danger test, right? Schenck was an anti-war activist in the United States. Of course, the United States is American politics. He was in New York. He was an anti-war activist in New York City. He was encouraging people to burn their draft cards, and he was arrested and told that basically since his speech would lead to a clear and present danger of other people doing illegal things, that his speech could be curtailed. Remember, most people think clear and present danger, they think fire in a crowded theater, but it's actually much more expansive than that. Though it's also not currently in effect. Remember, there is the 1964 case of Brandenburg v. Ohio that brought us the imminent lawless action test in order to protect the civil rights of the Klan. American history is not always fun. 1937, the National Labor Relations Board versus Jones and Laughlin Steel Corporation upheld workers' rights to unionize, and in the New Deal, a number of union laws were passed that required employers to recognize employee unions and hold union elections and bargain in good faith and all that good stuff. And Jones and Laughlin Steel wanted to go back to the old way of dealing with unions, which was, I don't know how many people are familiar with this, but back in the 1920s, in the wake of World War I, after that was over, the biggest consumers of tear gas in the United States were companies dealing with striking workers. So Jones and Laughlin Steel wanted to go back to, hey, just tear gas them. And the Supreme Court said, no, you actually have to respect your workers' rights to unionize. (1944) is Korematsu versus the United States. I'll probably put this one up for third worst Supreme Court decision of all time. Although I gotta admit, Shelby County versus Holder is really bad. Korematsu is the case about Japanese internment, where the Supreme Court actually found that Japanese internment was constitutional, was included in the president's war powers. As I mentioned before, the Korematsu case is particularly heinous because the War Department had a study saying that Japanese Americans did not pose a threat to the war effort and chose to suppress it rather than introduce it at trial in Korematsu. The Solicitor General's office had the paperwork. They chose not to introduce it because they wanted to get a ruling that confirmed what they were doing, which was pretty horrific. Right? I mean, Nazi Germany had their camps, but we had our own camps. They weren't extermination camps, but they were pretty bad. Again, I do encourage everybody to go visit Manzanar National Historic Site. It's just off. Take the 15 to Barstow, hop on the 58, head up the 395. It's a few hours from here, but it's a powerful place to go. You also see like what a horrible piece of country it's in. The Owens Valley is not a hospitable place. Brown versus Board of Ed. I think everybody knows this one. Brown versus Board of Ed struck down segregation in education. But remember, one, it only applied to education. It did not strike down segregation writ large. And two, it had no timetable for implementation. So Brown laid the legal framework for the end of segregation, but it really didn't do much to actually end segregation in its own right. That had to wait until the 1964 Civil Rights Act. We had 1961's Mapp versus Ohio. We remember Dolly Mapp and her suitcase full of porn. I'm not making it up. That is totally what the case is about. And gentlemen, if you thought ladies don't do that, now you know. But so Mapp versus Ohio is about the exclusionary rule. Police came to her house. They showed her a piece of paper that was not a warrant. They busted down her door, and they found not what they were looking for, but they found obscene materials which were illegal. The Supreme Court came up with the exclusionary rule, saying that if a cop illegally bursts into your house and searches it like that, they cannot use the evidence that they gain in that search at trial. 1961's Mapp versus Ohio introduces the exclusionary rule. 1963, my favorite Supreme Court case of all time, Gideon versus Wainwright. When Clarence Gideon, a random drifter from North Florida, pens his own appeal on prison-issue legal pads and manages to enshrine the right to counsel in all criminal proceedings for all defendants across the United States. So that if you are arrested and you cannot afford an attorney, one will be appointed to you, thanks to Clarence Gideon. Okay. We have 1971's Lemon versus Kurtzman. You'll recall this as the high water mark of the Establishment Clause cases. Lemon was about a program that put teachers in Catholic schools in order to make sure that, or it's a state-funded teachers in Catholic schools in order to make sure that students were getting good math and science education. And it was found to be unconstitutional, an unconstitutional government entanglement with religion. Remember, Lemon is kind of the high watermark for that view of the Establishment Clause, and future cases have generally been a lot more favorable to religion. 1973's Roe versus Wade almost needs no explanation. This is a case about the right to privacy and the right of somebody who's pregnant to terminate that pregnancy. It has typically, or the case did decide that that is covered under somebody's right to privacy, but future cases like 1992's Planned Parenthood versus Casey have whittled away at the right to abortion enshrined in Roe. U.S. v. Nixon, 1974. This is about executive privilege, right? Whether or not Nixon had the authority to be able to hide his records surrounding the Watergate hearings. The Supreme Court said no, by the way, that it's not something that Nixon can do. We had 2000's Bush versus Gore. Remember when I said standing is an issue more often than you think? This actually isn't standing, but it's a doctrine called the political question. So our courts basically say that we have an elected democracy, and judges aren't elected. So our courts have this doctrine called the political question doctrine, which says that some questions like elections and things like that are supposed to be decided by elected officials and not by judges. And so under the political question doctrine, in the Bush v. Gore case, was the Supreme Court didn't actually say, Bush won the election. What the Supreme Court said was, we're not getting involved. We don't want to have anything to do with the conduct of elections, which is properly the province of the elected branches of government. And so whatever decision the elected branch of the Florida state government that handles elections made would stand, and they obviously handed it to Bush. Let's see. We have NFIB v. Sebelius, 2012 case about Obamacare and the power to tax. So in the case of NFIB v. Sebelius, the National Federation of Independent Businesses sued because they said that Obamacare required them to either give their employees health care or pay a tax, and that it was unconstitutional to require them to purchase something. And as I said, one of the conservatives on the court, John Roberts, so the Chief Justice, actually switched over to vote with the liberals on that particular decision, saying that the power to tax is a valid power of the Constitution. And so if Congress wants to charge you $600 more a year in taxes because you don't buy health insurance, that is Congress's prerogative under NFIB v. Sebelius. Finally, 2015, Obergefell v. Hodges. This is the marriage equality case. This is a case where some same-sex couples who wanted to be married but couldn't get married brought a case against their state officials, saying they were violating the principle of equal protection under the law. Right? Saying that, hey, if I were straight, I could get married and get all these benefits under the law, but since I'm not, I can't, and I don't, and that's not equality, and so it's in violation of the 14th Amendment. The Supreme Court agreed and struck down gay marriage bans nationwide, including, by the way, both here in Nevada and in California. Actually, California has been struck down, as I said, under Perry, Hollingsworth v. Perry, which was a few years earlier, but in any case, Obergefell means that they can't come back. We hope. A lot of activists are very nervous that with a court that has taken a much more conservative turn, that anti-gay activists may file court cases to try and overturn Obergefell in the coming years. Indeed, some folks are worried that they're coming for Lawrence, which, if you remember, is the sodomy law one. So most of these cases were controversial when they were decided, And they involved significant judgment calls, not just on the substance of the case, but on the scope of the court's authority. That's always in question, like you saw with Bush versus Gore, right? The court didn't feel like it could step into and decide an election for the elected branches of government. So it said, you know what, we're not going to make that call. We will leave the decision in the hands of Kathleen Harris, Registrar of Voters in Florida. And she was a Republican, so you know what she decided. Most of these cases, like I said, were controversial when they were decided, and many of them remain so today. Let's wrap this up. Let's bring this down to the home stretch and talk about improving the judiciary. Because there are many criticisms in our legal system. One of the biggest one being that litigation is extraordinarily costly. In many cases, the victor of a legal action is not the person who has the better legal case, but the person who has the deeper pockets to hire better lawyers. And this is used commonly. There's a phenomenon of patent trolling. I don't know how many of you are in the tech industry and familiar with this, but there are whole companies that exist just to buy up patents from other tech companies, and then the only thing they do is they look through those patents for something that vaguely looks like something that, out in the world, and then they sue that company. They sue that company and send a threatening cease and desist letter, and typically what happens is that, a lot of these places are like small businesses, and they go, well, we can't afford to go to court, so I guess we'll pay the $1,500 they're demanding to license their patent, because that's cheaper than hiring an attorney to fight this. And so that is worrying, right? Especially when we have a legal system that is extraordinarily powerful. We have a legal system that can take away your money, your liberty, even your life in the right circumstances. We also have a legal system, especially in the criminal justice system, that carries with it systemic institutional biases, typically against those who are marginalized in other areas of our society. So our criminal justice system treats black people, especially black men, much worse than it treats, their white counterparts. Legal system bias exists throughout the system. I should mention that it's not a great system for LGBT folk either. So what should we do about it? Well, one thing we could do is just pay our judges better, because if you're worried about corruption, well, if your people are making good money on their own, they have less reason to want to take bribes. But in most cases, we have a relatively small budget for our judiciary. In most states, actually, the court systems are mostly funded off of court fines and fees. So if you're wondering why a $150 speeding ticket costs you $238, it's because you're paying for the courts. But it's hard to attract judges right now because judges don't get paid all that well. And hell, here in Nevada, it's an elected position, so you don't get paid all that well, and you have to run for your job every 4 years. So it's a tough thing. So maybe just shifting more resources to the courts would help. Or how about term limits? So we have, in our federal judiciary, we have lifetime appointments. And some people are saying, well, that causes problem, because on the one hand, it means that if you appoint somebody who's in their 40s, then they could be around for decades. And that's a problem, because that really breaks that chain of democratic accountability. So some people have proposed, 18-year judicial term limits. So there's 9 Supreme Court justices. If they had 18-year terms, that would give you, and they would stagger them so there was a new justice coming off every 2 years. So that would mean in every presidential term, you got 2 appointments, one at the beginning, one in the middle, and that might reduce the battles that currently surround judicial appointments. Because right now, it's like, this is for the soul of the court for the next several decades. If it was only for 18 years, maybe that would reduce the stakes around judicial appointments. Um, there's also some proposals that say, hey, we should probably shift some of this authority that's been taken by the Supreme Court, like the ability to set law through precedent and interpret the Constitution. Maybe we should shift some of that authority to a branch of our government that's actually elected, like Congress. Give Congress the ability to modify court precedents or overrule them without the current requirement, which is a constitutional amendment. Or allow Congress to issue advisory opinions as to the interpretation of the Constitution. Because at least this branch of government would actually be elected. Now, personally, I'm looking at least the Senate right now and thinking, God, I don't want to give them an ounce more power. But, it is a proposal that's on the board. Anyway, that is my conversation on the judicial branch. And so that actually concludes my discussion of American politics in general. Congratulations. You're almost to the end. We're going to pick up with Nevada politics when we come back on Thursday morning. And then we'll finish off a week from today. Also want to remind folks that essays are due Friday at 5. Friday at 5 on Canvas. So make sure that you are getting your papers in, because it would really suck to do all this work and then not get the paper in and fail because of it, because paper is 20% of your grade. If you don't do it, it'll suck. If you do it and you half-ass it, then you're probably going to get 50%, but that's better than 0, right? Just don't cheat. Please don't cheat. Please don't cheat. I don't want to have to go through the process. And if you're unsure what cheating is, we have a lot of resources online to help you through that. Check with the library. Beyond that, stay in place, keep your space, cover your face, stay safe out there, and I will see you all on Thursday morning.